Hello and welcome to News Centre. With me, Parikshit Luthra. The top story we have been tracking. The Supreme Court has declined to transfer the Adani-Hindenburg case to the CBI. The apex court has given the market regulator SEBI 3 months to conclude its ongoing investigation in the matter. A three-judge bench led by Chief Justice D.Y. Chandrachud further allowed SEBI to assess any violation of norms by the Hindenburg report. Remember, the US-based short seller had accused the Adani Group of stock manipulation in January last year. Ashmit Kumar is here with all the details. He was there in the Supreme Court. He has been tracking this major case with implications for the stock markets, for the regulators for the last few months. He takes us through the key contours of the judgment from the apex court.
Well, fresh out of the winter break, the Supreme Court dived straight into the midst of action, coming out with the much-awaited verdict in the Adani-Hindenburg saga. Here are the important takeaways. Number one, the Supreme Court records in its judgment that SEBI had launched 24 cases of investigations into issues raised by the Hindenburg report. The Supreme Court records that out of 24, probe has been completed in 22. The Supreme Court has directed for the remaining 2 to be completed in 3 months' time. The 22 probes which have been completed, Supreme Court has directed for them to be taken to their logical conclusion. Number 2, the petitioners had sought for the issue to be investigated by the CBI. They had also sought for a court-appointed SIT to probe the allegations. The Supreme Court has given an unequivocal no. The Supreme Court held that no case has been made out for transfer to the CBI. The Supreme Court also recorded in its order that report by third parties like Hindenburg and OCCRP cannot be treated as gospel truth. Number 3, the petitioners had raised allegations of conflict of interest against members of the expert committee appointed by the top court. The Supreme Court has rejected these claims by the petitioners. The Supreme Court held that no case of conflict of interest has been made out. Number 4, on the issue of regulatory framework, the Supreme Court noted that as opposed to petitioners' claims that FPI norms were diluted to allow mischief, the disclosure norms were rather tightened. The Supreme Court held that no grounds were made out for revocation of the amendments made to the FPI and LODR regulations. The Supreme Court has also directed the Centre and SEBI to consider the expert committee recommendations for strengthening the regulatory framework. And finally, number 5, Supreme Court has directed SEBI to probe short selling by the likes of Hindenburg. The Supreme Court has directed to probe if actions by Hindenburg may be in violation of Indian laws. The Supreme Court has also asked for suitable action in case of violations of existing regulations. Now, while findings of the SEBI investigations are not known yet, leading legal voices are pitching this verdict as an exoneration for Adani, given that no criminal probe has been directed by the top court.
Instances which have been investigated, the fact that there is an exoneration is a shot in the arm for the Adani Group. As regards to that, investigation will take place and whatever its conclusions will have to be considered by the court at the appropriate stage and a view taken. That we will have to await.
So just one word as far as the SEBI regulations are concerned. There were questions raised about the existing framework. To that end, Supreme Court very clearly has held that there is no dilution of FPI norms, rather they've been tightened. Does this perhaps give an indication of the current framework in place, or more work needs to be done? Expert committee regulations also need to go into?
As of today, the Supreme Court has appreciated the work that has been done and has therefore said that nothing further needs to be done on the regulations. In any case, the Supreme Court does not sit over a legislative exercise, which is the domain of SEBI, and that is what they have said. Having said that, in my view, keeping in view the changes in technology, keeping in view the changes in the ways of doing business, there is always need for regular upgradation of regulations, because that is the whole purpose of having delegated legislation, so the government can keep adding and making robust mechanisms to ensure that transactions and the regulatory mechanism is strong, robust, and the interest of investors is protected.
One final question, sir, on the question on the credibility of Hindenburg report, OCCRP report. Supreme Court has had some very stern observations to make that it can be only supplementing the investigation. It cannot satisfy being concrete proof.
In every mechanism, in every nation, there are regulators which operate, and once the Supreme Court has given a vote of affirmation to the functionality of SEBI as also to the regulatory mechanism, clearly the report of SEBI has to have precedence over any private reports. It is important that when private investigations come, that those may be looked at. But since SEBI has now, I would say, put a quietus to the whole issue, the matter stands resolved.
See, SEBI investigation, as I said, 22 out of 24 instances is complete. The remaining 2 will be completed in the next 3 months. But as far as the court judgment is concerned, it clearly said does not warrant any criminal investigation, including that of CBI. And it trusted SEBI to do its own investigation. So according to me, it is exoneration of the Adani Group, because they have been saying that we have done nothing wrong. This Hindenburg is a malicious body which is only interested in its own profits. That's about all. So once the Supreme Court has said that no other investigation is required, if they had been guilty of some misdemeanors, the court would have ordered some criminal investigation, but that has not been ordered.
On the Hindenburg OCCRP report, the Supreme Court has said that it cannot be met as a gospel truth. Obviously, and that they need to be investigated.
Because, that is a report which has come like ex parte, it has come from abroad, nobody has seen it, nobody has been heard, nobody has been, participate in that. So we are participating in the SEBI investigation. We also feel the SEBI is a fair and impartial body, as the court does, and therefore SEBI will decide. That's all.
So questions were raised on local regulations, existing regulations. Has that been answered?
Supreme Court has clearly said that there is no further need for the court to direct any regulations to be made. SEBI is a body, it can do whatever it wants. It has made large number of regulations. If it wants to make more, it certainly can make more.
All right, so that was the Adani-Hindenburg verdict in the Supreme Court. The other big...
For more news and updates, all you need to do is follow CNBC-TV18 on all of our digital platforms.